Below is a strict legal mode analysis of your question, based entirely on the docket you provided. Short answer, yes. The court restricted his complaint, not by page limit, but by forbidding piecemeal filings, requiring him to use the court's approved form, complete all sections, and submit one complete complaint. An 800-page amended complaint almost certainly violates the court's orders. It is overwhelmingly likely to be struck, rejected, or ordered refiled, and the case may be dismissed if he continues failing to comply. Now here is the detailed legal explanation. Number 1. What the court actually ordered, page limits versus form requirements. The docket shows 3 orders directing him to cure deficiencies. August 6, 2025, order directing plaintiff to cure deficiencies, ECF 7, required him to fix specific issues with his initial complaint. August 13, 2025, second order directing plaintiff to cure deficiencies, ECF 12. This is the most important one. August 28, 2025, minute order clarifying requirements, ECF 17. This spelled out the rules even more clearly. 2. The court did not set a page limit, but it did impose strict restrictions he violated. The court's critical instructions from ECF 17 were, open quote, all sections of the complaint form must be completed in full. Close quote. Open quote, plaintiff may not incorporate other filings. Close quote. Open quote, the court will not accept piecemeal filings. Close quote. Open quote, plaintiff must submit one fully completed complaint on the court-approved form. Close quote. Open quote, the complaint must be filed as a separate document and not an attachment to a motion. Close quote. These instructions directly contradict and forbid an 800-page amended complaint. Number 3. Why an 800-page complaint violates the court's orders. A. It is impossible to put 800 pages into the District of Colorado's approved prisoner complaint or pro se complaint form. The form is 10 to 12 pages. Adding 800 pages contradicts the explicit rule that the form must be completed in full, not replaced, violates the rule that you cannot attach massive supplements or alternate pleadings. B. It is explicitly forbidden to file piecemeal or interspersed documents. The magistrate judge said, open quote, the court will not accept piecemeal filings or pages meant to be interspersed with or attached to a prior filing. Close quote. An 800-page submission is exactly that. C. It violates Rule 8, short and plain statement. Federal Rule of Civil Procedure 8-2, open quote, a short and plain statement of the claim. Close quote. Courts routinely dismiss complaints between 70 to 200 pages as violating Rule 8. An 800-page filing is almost guaranteed to be rejected under Rule 8 and Rule 12b-6d. It disregards the court's direct orders. Ignoring the cure orders triggers dismissal under Fed R-Civ P 41b, failure to comply with a court order, DC Colo LCR 41.1, failure to prosecute, failure to comply, 28 U.S.C., PAC of 1950E, 2, screening dismissal for frivolous or defective complaints. Number 4, what the court already warned would happen. Every deficiency order includes, open quote, if plaintiff fails to cure all the designated deficiencies within 30 days, the action will be dismissed without further notice, close quote. The court said this multiple times. ECF 7, ECF 12, ECF 17, ECF 23, Sept 17, 2025 order. Filing an 800-page amended complaint is not curing deficiencies. It is the opposite. Number 5, bottom line, legal conclusion. Based strictly on the docket and rules, the court did not impose a 30-page limit. The court did impose a structural limit. Use the court form. One single, complete filing. No attachments. No piecemeal additions. No incorporation by reference. An 800-page amended complaint heavily violates all of these rules. The filing is almost certainly procedurally defective. The court is likely to strike it. The case is likely to be dismissed if he continues not to comply. If you'd like, I can draft a judge-style order explaining exactly how the 800-page complaint violates the prior orders. Show you how the magistrate judge will likely respond. Summarize the factual contradictions between his filings. Provide a dismissal likelihood analysis under Rule 8 and Rule 41b. Just tell me which direction you want to explore.